note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Gisela K. This is Grizzly True Crime, and today we are back to talk about the Delphi case. If you've never heard of this case before, please check out my description box. There's a little write-up there for you, and there's also a link to the playlist because we've discussed this case at length with presentations, maps, and all the documents. So many documents. But honestly, it's so interesting. Every time there's a document that comes out, I'm like, what happened now? So yeah, we got to keep up as well if we want to stay on top of this case, because it just never stops. It's, 12 days to trial time. It's May 1st today. Happy May, everyone. And so the trial is set to start on May 13th, okay, with jury selection. The jury selection will last 3 days. Sorry, I'm just trying to bring up this document for you. It will last 3 days, and then the judge said that the trial will happen on Saturdays as well, full days on Saturdays. She'll start at 9 every day, go to 5 or 6, and then also on Saturdays. So, oh my word. Welcome to all my moderators. Thank you so much for everything you do. Welcome to all my patrons, members, subscribers, anyone that's new over here. Thank you so much for being here, especially everyone that is interested in this case and patient with me as we work our way through it. I know all these documents are not for everyone, but my goodness, I just can't look away. Every time I look, I'm like, what? And then what happened? So as you saw in my thumbnail, the former judge, Judge Benjamin Diener, has, I guess the word would be retired. He is retired. He's just suddenly, literally suddenly, just no one expected it. They said it's all in one day, just like swiftly, April 30th, gone. He's leaving. Let me just quickly fetch something here so I could show you. Okay, hold on. Sorry, trying to get all the things here for you. It should be here. I put this on my community tab about an hour or so ago. 3 hours ago. Wow, it feels like an hour ago. Okay, so they say circuit court judge leaving the bench. So remember, this was the judge that was initially assigned to the case, and then after signing off on the search warrant and on Richard Allen being transferred to the Department of Corrections, which was the Westville Correctional Facility, he recused himself. That one. He's suddenly running for the hills, and I'm not too sure why. Don't know what's going on here. So this is on the community tab if you didn't see it, okay? Lutina says, wow, Saturdays too? This is so crazy, especially for the jury schedules. I know, right? Yeah, Chelsea said he's resigned, not retired, but he's resigned from the bench. So they say Judge Benjamin A. Diener, judge of the Carroll Circuit Court, made the following official announcement on Tuesday morning, April 30th, 2024. Judge Diener has notified Chief Justice Rush and Governor Holcomb that he's leaving the bench. So that would be notifying the Supreme Court of Indiana, right? His last day is April 30th. He loved serving and appreciates all the people who supported him along the way. Like, oh, okay. That is him. And here they say Diener was first elected to the bench as Carroll County Circuit Court judge in 2012. A native of Monticello, Indiana, Diener received a BBA degree from Indiana University and a JD degree from Barry University. I wonder where he's going now. Dwayne Andreas School of Law. In 2007, Diener was admitted to practice law in Texas and was an assistant AG with the Texas Attorney General Office. In 2009, Diener was admitted to practice law in Indiana and was in private practice prior to assuming the bench as judge of the Carroll County Circuit Court in 2012. So, I could see all over X, if you go hashtag Delphi, right? You'll see a lot of updates there. Everyone's talking about this and just questioning when and how he signed off on the probable cause affidavit and the search warrant and all of that stuff. Pamela says, don't tease me. I thought you meant Judge Gull retired. Well, I said former judge. Former judge. I even put the former judge's face on the thumbnail. So not Judge Gull. Sorry about that. But for the first time ever, Judge Gull has actually agreed with the defense on something, which I'm like, wow, this is amazing, right? Okay, so let me just check that everything is okay. Good, yeah. Seekin Ireland says sus, giving resignation. It's a little bit sus given the timing, right? As I said on my community tab, I mean, normally one might not really read into something like that so much, but in this case, given the context of everything, given what the defense attorneys seem to be digging up, week after week. Oh, I don't know. It's interesting timing, right? Okay, so Janet's like, no denial? No denial? You mean? Okay, are we talking about the contemptuous conduct or what? So we're going to look at this. There's a couple of documents, okay? So just bear with me. I know it's a very document-heavy case, especially it's been for a while. But as I say, I find it very interesting. So first, what do we even look at first? My goodness, there's so many things. Look at this. Okay, first, remember we looked at the motion in limine filed by the state in the last episode. If you didn't see it, go check it out because I was like, whoa, this is just so shocking what Nicholas McClelland is asking for. Basically banning words from the trial, but so vague, making it so broad and so vague that basically it seems like the defense can't even defend their client, So I was actually saying, are they not allowed to have reasonable doubt? And someone in the comments said, it's not about not having reasonable doubt, that they're not allowed to mention third-party involvement, which that I can understand. You can't just point fingers at someone else. I get it, unless they've got evidence, to connect those dots to the case somehow, which the defense seems pretty confident that they're going to do. So I guess we'll see, or we won't. You know why? Because Judge Gull is banning cameras, audio, everything from this trial. So only the people who are in the courtroom will actually be able to see anything. But yes. Angel Fire, hello, and thank you for being a member for 1 year. Tina says, I wonder if he's going to spill the tea. Oh, that would be interesting. That's a good take on that. So remember this, where McClelland, as an example, said, the state requests such order in limine to include, but not limited to, the following. They may not talk about Odinism, cult or ritualistic killing, Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Ken Klein, Jerry Klein, and Ron Logan. Okay, there's like a lot of words they may not say. Don't allude to it. Don't talk about it. Don't offend your client with this. So the thing is, this is a motion in limine, which guess what? The judge has said there will be a motion in limine hearing on May 7th. So the trial starts on May 13th, but before that, on May 7th, there's actually going to be a hearing. And I'm like, wow, because yesterday it was being reported, I just follow everything on X and all over the news that I can, and they were saying that it seems like there's going to be no more hearings whatsoever right before the trial. Judge Gull says, that's it, we're starting on May 13th, this is how it's going to work, and you will not have any more time, because the defense is asking for more time for the trial, because they're saying from the 13th to the 31st is a little short, given that it includes jury selection and the state to present their whole case. Like, how much time do they even have, right? Stefan's like, not talk about Slick Nick's haircut. Did he have a haircut-y? So the motion in limine we've gone over before. Now, so the important thing to know, I'm trying to just, almost defluff all these documents for you so that I could just tell you what's happening, because I've read through all of them. So what's happening? So there will be a hearing for this motion in limine because, of course, the defense attorneys, I guess you could say, clapped back. They said defendants' response to the state's motion in limine and request for hearing. And so they say here that the defense was saying, the court said without any prompting by lawyers from either side, included the following statement, I am quite familiar. So Judge Gull, right? I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators in the charged crimes, those allegations are unsupported and will be inadmissible. So that was a blanket statement that Judge Gull made, okay? So, Connie says, I've been following you for 2 years. You're the boom. Am I the bomb? And I hate that it's not going to be on TV because we're not going to hear you snarky. I know, right? I was like, do I need to book a ticket? Do I need to go over there? But damn, this courtroom sounds small and the seats are very limited, okay? So Judge Gull said this, and then the defense says in their response, Defendant Allen's defense team is quite familiar with the law regarding the admissibility of evidence of third-party perpetrators, which requires only that Defendant Allen establish some connection between the third-party perpetrator and the crime. The court must balance Defendant Allen's Sixth Amendment right to present a defense with the state's desire to limit such evidence. Wow, so they just like, we are also aware of the law. And yeah, you cannot just ban us from talking about any of this stuff, right? Okay. My goodness. Thank you so much, Sherry D. You said this channel is seriously top notch. Just want to say that, and catch you bears later. Catch you later. I hope you'll watch the replay. Okay. Fierce says, I'm so glad you love documents and are good at defluffing. Oh, thank you so much. Okay. So they said, because now how many witnesses will the defense have, right? The defense at this trial anticipates that its trial presentation will, we already like those words, trial presentation, okay, will include somewhere between 1 to 2 dozen witnesses that will provide relevant and credible information for the jury regarding culpability of third-party perpetrators. Okay, to the extent the court carries out its warning reference. So here they're saying basically they need more time. Judge Gull said, don't mess with me. Sorry, I should say another one. Judge Gull says, listen here, defense attorney, this trial isn't sort of happening from the 13th to the 31st. It is happening from the 13th until the 31st. She made that very clear yesterday. If you were at the Patreon only stream, I think we talked about it there. I showed you that little email as well. Debs, welcome. Bertie B says, you would not go for a truck of Chucky. A truck of Chucky? I said to Mr. Grizzly, must I go? And he said, I'd be afraid for your life. And that's what he knows about Delphi. He's just like, I don't think you should go there. Anyway, I wish the courtroom was huge and that I could go there, because I'm like, what? So they say the defense requests that the courts set the state's motion in limine for a hearing for a full day during the week beginning May 6th. And guess what? Judge Gull set it. So actually, there's 2 things that the judge has finally agreed with the defense on, just for one time, you know, just like breaking the pattern. Rob was saying on X, she's not feeling well. Like, oh my word, is Judge Gull okay? Because she's like, okay, defense, yes, we'll have that motion in limine hearing and a pre-trial hearing. And I'm like, whoa, they're going to have that hearing? That's interesting. Here, of course, you know, the defense is arguing with the state's comments and just saying it's too broad, it's too vague. They can't just limit all these words. And so, number 1, judge says, yes, you can have a motion in limine hearing. And number 2, they were not. She has voted or decided that the defense was not in contempt of court, that there was no contemptuous conduct. Although she said it in a way that she's like, they were sloppy, okay? They were, we're going to look at it. She said a few things and then she's like, okay, but the state did not prove that they had contemptuous conduct. So I'm like, ooh, that's 2 losses for McClelland. Now, normally I wouldn't be all that excited about the prosecution, you know, in a case in general. I wouldn't be like, oh, 2 losses for the prosecution. But in this case, I'm like, what has been going on? Finally, maybe the defense can be heard a little bit, right? Norm says, I wish you'd go, G, but they probably have you on some kind of list that won't let you through the door. I could always put on a wig. Hello. Different accent. Shall I put on my British accent? Okay, so this paragraph 9 says the state, okay, seeks to limit the defense's ability to challenge the state's geofencing expert, Kevin Horan, based on relevance. The state's request is overly broad, contains no specific facts, which the state is seeking to limit, and usurps the defendant's Sixth Amendment right to present a defense. Therefore, the state's request should be denied. So here they're just telling Judge Gull, it's over the top, what McClelland's asking for. Therefore, Judge Gull is going to have a hearing where the defense is going to argue all of this on May 7th. Okay, so we could close this one. No. Okay. Then this one, I'm just trying to power through some of the quick ones, and we're going to look at cell phone pings. That one was very interesting from the defense, because they're claiming Libby German's phone was not at the crime scene the whole night. That was interesting. So we're going to look at that, right? Okay. Cook 13 Doodle says, send Diener to the courthouse. That's a very good idea. Okay, so here the defendant's notice of submission of supplemental witness and exhibit list to the state. So they're just saying that they have respectfully notified the court that the defense has turned over a supplemental witness and exhibit list to the state, outlining the witnesses the defense may call and the exhibits the defense may use at the trial. Okay, then we'll look at this in a moment. Oh, there's so many documents. Oh my goodness. Now, where's the court decorum one? I had a court decorum one as well. Just hold on one second. Let's see if I can find it quickly. Can you still see me? I hope so. Let's just see. Do I have it here? I've got so many. I've got so many documents. Hold on. Let's see. I know MB Inc. sent it to me earlier as well. Is it this one? Yeah, decorum order. Okay, let's get it. Let's get it. Stand by, everyone. Are you excited? Is it this one? Yeah, okay. This one, sorry that I go all like bright when I put this bright white paper on. That's why I like dark mode, but not all documents can do it. Look at that. Isn't that so nice? Oh, Adobe, can all documents please do it? So here, they say, you know, the trial will be May 13th to the 16th. Huh? Wait, I'm like, wait, what? Sorry. Jury will be selected between May 13th and 16th in the Allen Superior Court, and then after that, the trial will be held at the Carroll County Court. Okay? So they talk about the courthouse will be open at 8 a.m. And if you look here, they say all members of the public, including members of the media, are subject to screening by metal detectors. No weapons, of course. No electronic devices, including electronic watches, are permitted in the building. Wow. They talk about the media having five seats allocated to the media. So public seating in the Allen Superior Courtroom 1 is extremely limited. The sheriff of Carroll County or his designator will ensure that the victim representatives are seated and that the defendant's family is seated in 6 reserved seats in the back of the courtroom. The credentialed media is allotted 5 seats to be divided at their discretion. The court will not mediate any dispute regarding seating, and they say the remaining seat in the back of the courtroom, if any, is available until full. No one, other than court security and law enforcement, will be permitted to stand in the courtroom. Okay, so the courtroom will be locked between sessions of the court. Doors will be unlocked for the afternoon session at 1:45 p.m. So they're going to start every morning, at 8. They've got to be there at 8 for 9, I think. We'll open at 8, start at 9, go until 5 or 6, and it's Monday to Saturday. And it's from May 13th until May 31st. And Judge Gull says jury selection is May 13th to 16th. It's 3 days. Then the trial will kick off, okay? And the jury will be sequestered. So now we've looked at that one. Now, what do we have here? Let me go through my list quickly in my head here, because I'm like, I have to tell you all these things. MB Inc. says her courtroom sounds worse than county jail. Yeah, it sounds pretty bad, right? So number 1, the former judge, Benjamin Diener, has suddenly resigned, which is a little strange given the context of this entire case, and the defense questioning the search warrant that he signed off on, and then also the, handing him over to the Department of Corrections at Tobe Lesenby's request, all of that. I don't know if that's not coming into question or why he's resigning, or I don't know. I've seen some rumors. I have no idea, but I think it's a little bit odd. 12 days before the trial starts, the former judge, Benjamin Diener, resign. 2, we know that there's now going to be a motion in limine and pretrial hearing on May 7th. 3, the judge has decided that the defense attorneys did not have contemptuous conduct. Now, I first want to show you that, then we're going to look at this, because this is all about cell phone pings, and I find it quite interesting as well. So let me quickly fetch what I wanted to fetch. I know where it is now. It helps me to go over that list, isn't it? So I don't have this document yet, but I have this from the... Oh, no, we got to resize this for you. Hello, work with me. Here we go. We've got this from my case. It's Public Courts, Indiana Gov, my case, right? Okay, so, yes, Vicky says jurors are sequestered for the entire trial. Yes, for the entire trial, and they get Sundays off to rest. So I don't have this document yet, but they say here what it will say, right? The court now this is all about the contemptuous conduct hearing that was held on March 18th. And it's been this entire time waiting, and it's what I've been a little bit nervous about, like, what is she going to decide? Waiting for Judge Gull to decide if the defense did have contempt of court, did have this contemptuous conduct. Because after the issue was addressed at the Supreme Court of Indiana and the attorneys were reinstated, the prosecutor decided to resubmit this filing of contemptuous conduct. So even though they said, okay, just focus on the trial now, stop fighting with each other, McClelland decided, no, the fight continues. These attorneys need to be off the case. And so the judges decided, no, they're staying on, number 1, and that the state did not meet its burden to prove the contemptuous conduct. So let's read it. The court, having had this matter under advisement following a hearing conducted on March 18th and having reviewed the evidence admitted at the hearing, the court did not review any evidence that was offered but not admitted. The arguments of counsel and briefs and memorandums submitted by counsel now finds that the state proved by a preponderance of the evidence that the defense counsel was sloppy, negligent, and incompetent in the handling of discovery material. So she's saying, look, man, okay, yes, McClelland, they were sloppy, negligent, and incompetent in the handling of discovery materials. Counsel failed to properly secure evidence and discovery material in this matter. counsel negligently allowed the discovery outline to be sent to an individual unrelated to this matter, which was Brandon Woodhouse, who then disseminated that information to the public. Counsel further allowed their discovery materials to be compromised by Westerman, who, by the way, is accepted a plea deal from what I saw as well from his case. One of the leakers, right? Okay, so they say who in turn provided information to Fortson and Cohen. Fortson, the guy who took his own life with all these, all the leaked crime scene photos and all of that whole topic we've explored before, right? And so they say counsel has described Westerman both as a criminal and a valued consultant and confidant. Despite this court's findings of, she has to rub it in again, despite this court's findings of sloppiness, negligence, and incompetence, the state is required to prove that counsel's conduct was willful and intentional beyond a reasonable doubt for the court to find counsel in contempt. My question is, then why did she find them in contempt the first time? Why were they dismissed the first time then? Because this time she's like, look, man, state would have to prove that they were, and I'm like, oh, well, that's how it should have been the first time. Exactly. That's why they got reinstated. So they said, as the state has not met that burden, the court declines to find them in contempt of court for violating the protective order issued on February 17th of 2023 regarding discovery. The state has also alleged that defense counsel violated the gag order issued by the court on December 2nd of 2022. Defense counsel issued a press release on December 1st of 2022. The release contains statements that are potentially violative of the rules of professional conduct. As defense counsel's counsel correctly argues in his post-hearing brief, the gag order was not yet issued. As such, the court declines to find counsel in contempt of court as no order was in place. Shame, McClelland is losing so much today. Yeah, MB's like pot calling the kettle black. Yes. So then she goes on to say, yes, okay, in place. To the extent that the press release violated the rules of professional responsibility, the trial court has no jurisdiction to enforce those rules. As required by the rules of professional responsibility, the trial court will, so now this is an action that she's going to take, therefore, send a copy of this order and the press release to the Office of Judicial and Attorney Regulation, Executive Director Adrian Mehring, for that office to enforce the rules or determine counsel's ethical misconduct. So it's kind of like, well, I will say that they, that the state did not prove that they were in contempt of court, but I'm going to hand this over to someone else to also decide. Basically, like, get a second opinion. Am I reading that right? Oh, Stefan says, take that, Slick Nick. I know, right? So I think he's not having a good day today. He's like, come on, what's happening? Anyway, so then, as I say, there's a lot of documents. We're going to just, this one is the accused's reply to the state's motion to compel and sanctions and request for the state of Indiana to be further sanctioned for providing false information in its response. So these are very long documents. I'm not going to spend too much time on this now because I want to focus on the cell phone pings one. So we'll go to the bottom and summarize. Wherefore, Richard Allen, by counsel, files his reply to the state of Indiana's response and respectfully requests the court sanction the prosecution as previously requested in its motion to compel and motion for sanctions. Sanction the prosecution for providing false information in its response. As a result of said sanctions, to order the prosecution to provide an itemized list of all documents, videos, recordings, and other evidence provided to Mr. Allen's attorneys and the location of each item. 4. Order the prosecution to explain misleading and false representations contained in its September 6th, 2023 email. And 5. For all the other just and proper relief in the premises. McClelland, the pressure is on. The pressure is on. Somebody's asking if I'm frozen. I'm not frozen, right? Am I good? Yeah. Mandy, you're saying it like I... But Mom! Little bit. Okay. So, let's quickly go to this one. Okay, I found this one very interesting when I read this yesterday. Let me just quickly see. Yeah, Delphine's handcrafter said it sounds like they didn't break the law, according to the judge's statement, but they broke the ethical code and responsibilities. Sloppy, negligent, and all of that, but not the code. Yes. Okay, now Gaynor says, I meant, anyone else think that maybe she's being threatened? I wonder. I don't know. Okay, thank you. Tracy also says, I'm good. Thank you, Copper Horse, for providing that solution. Okay, so this one is 8 pages long. So here we go, okay? Defendants Richard Allen, fourth Frank's motion. A fourth Frank's motion based on newly disclosed evidence and request for a hearing. We know that Judge Gull doesn't like their Frank's motions, okay? But it's very interesting. Comes now, the defendant Richard Allen by counsel, Andrew Baldwin, Bradley Rosie, and Jennifer Auger, I never know how exactly to say her name. I want to say Auger. And for his motion to compel, states as follows. General background, right? On September 18th of 2023, Mr. Allen by counsel filed his first Frank's notice, which included a 136-page Frank's memorandum. Remember that. Okay, in support of the notice, in which detailed the following. Certain evidence that Carroll County Sheriff Tony Liggett failed to include in his search warrant application for the residence of Richard Allen under cause number. Certain evidence that was detailed in his search warrant applicated for the search warrant that was false. And evidence that law enforcement had acted in an intentional manner on multiple instances, attempting to conceal evidence from the defense and failing to tell the truth under oath concerning certain evidence. 2. Mr. Allen, by counsel, incorporates his first Frank's notice and memorandum filed on September 18th of 2023 as is fully outlined herein. Okay, number 3. On October 3rd of 2023, Mr. Allen, by counsel, filed his second Frank's notice. Detailing how the prosecution and law enforcement had attempted to conceal the identity of a Purdue professor whose testimony contradicted that of law enforcement officers Tony Liggett and Jerry Holman of the Indiana State Police. This notice was provided as a supplement to the first Frank's notice in order to bolster the defense contention that the state of Indiana and law enforcement were acting intentionally and or with reckless disregard of the truth to further support the request for a Frank's hearing. It gets interesting with a cell phone ping, so hang in there. Mr. Allen, by counsel, incorporates his second Frank's notice filed on October 3rd, 2023, as if fully set out hearing. Now, the reason I'm reading all of this to you from the top is because I say yo, like I'm South African, right? Yo. So that just means like, wow. They're really laying it all out now. They're not playing here. They're like, listen, look at all of this. I really think it's a good defense team. You know, I think they're working really hard. And I'm pretty sure the prosecution, that's why he wants them off the case, right? And Judge Gull picked them initially, remember? The public defenders. Hope it fears says all these Frank's motions might as well bring beans and call it a meal. Frank and beans. So many Frank's motions. So on March 13th of 2024, Mr. Allen by counsel filed his third Frank's notice, herein after Frank's third, based on evidence recently provided by the prosecution. Frank's 3 detailed the following information omitted from the search warrant. A. At least 3 persons were in or around the crime scene at the time the murders were allegedly taking place, and none of the owners of the phones had any connection to Richard Allen. B. Purdue professor Jeffrey Turco wrote in a report provided to the Unified Command that the markings, referring to the configuration of the branches on the girls' bodies, constitute an inscription inspired by Norse runes, or modern recreations thereof, is quite plausible. 6. Mr. Allen, by counsel, incorporates his third Frank's motion filed on March 13, 2024, as set out herein. Additional facts. Okay, now, here we go. On Friday, April 26th of 2024, the prosecution provided numerous documents to Mr. Allen's counsel as a result of the motion to compel and motion for sanctions filed April 23rd of 2024. I still find it unbelievable that the defense is still just trickling in this little bit of information that the state is trickling in this little bit of information that the defense needs. Like, it's 12 days before the trial now, and the state is still hesitating to hand over what they need to hand over for the discovery? I mean, yeah. So Malibu said, this is all about documenting the record for appeal. Yes, indeed. So, they said on Friday, on April 26th. So just think about that. Think of the day today. Wow, last week Friday, the prosecution had handed over these numerous documents. Contained in the documents provided by the prosecution are pages 2 and 3 of an incident report authored by Steve Mullen of the Delphi Police Department. These 2 pages indicate that Steve Mullen contacted Sergeant Mitch Blocher of the Indiana State Police at approximately 9 p.m. on February 13th of 2017 to assist with acquiring precise location information for a cell phone using some of their more technical assets. It appears that the last communication with Sergeant Blocher was prior to 1 a.m. on February 14th of 2017. The 2 pages provided to Mr. Allen's counsel contain the following summary of a conversation between Steve Mullen and Sergeant Blocher of the Indiana State Police. Sergeant, I hope I'm saying that right, Blocher. I'm going to say Blocher. Again, it's sounding a little German there. Okay, Sergeant Blocher advised, according to his evaluation of the data provided by AT&T, the last contact event between the cell phone and the tower located at Wells Street was 17:44:50 hours. He advised that according to the records provided by AT&T, there had been no contact with the phone since then. Sergeant Blocher advised that his interpretation of the information which we were receiving from AT&T indicated that the cell phone was no longer in the area or no longer in working condition. He advised that since there has been no change in the every 15 minutes update we were receiving and the last known contact time had not changed since 17:44 hours. Okay? Spaghetti Lee says, what's that courtroom capacity? 30 people tops? Is there anyone local who knows the actual capacity? Because it doesn't sound like a lot. It really sounds like 30 people. I mean, whoa, I'm sure there's a lot of interest and people are going to be lining up outside those doors to get in. Especially because Judge Gull won't allow cameras or audio, not even an audio-only trial. So they say, number 11, the conversation appears to have occurred prior to 1 a.m. on February 14th of 2017. On November 9th of 2023, the prosecution provided Mr. Allen's counsel with evidence of 44 pings generated by AT&T to locate Libby German's phone, one of the victims. Hereinafter pings. There were 2 pings from February 13th of 2017 in the pings provided to the defense counsel, one at 5:48 p.m. and at 7:16 p.m. Mr. Allen's counsel did not learn of additional pings which took place every 15 minutes on February 13th of 2017 until the discovery disclosure on April 26th of 2024. Defense counsel still does not have the additional pings from February 13th of 2017 or the early morning of February 14th of 2017. Pursuant to the information which the prosecution disclosed to Mr. Allen's counsel, the first ping on February 14th of 2017 was sent to LG's phone at 5:39:41 a.m. Okay. Spaghetti Lee, you said Superintendent Sniffles Carter. Well, here it was sniffle free, but yes, Sniffles Carter will be scalping tickets. Rexy said Gull doesn't want to stream because then she can't hide her shenanigans. Oh my. I really wonder what the outcome of this trial will be. Okay, so then they say, right, on the early morning of February 14th, pursuant to the information which the prosecution disclosed to Mr. Allen's counsel, the first ping on February 14th was sent to Libby's phone at 5:39:41 a.m. More importantly is Sergeant Blocher's statement that his interpretation of the information which they were receiving from AT&T indicated that the cell phone was no longer in the area or no longer in working condition. The prosecution's entire case rests on the idea that LG and AW, those are the victims, were on or very near the south side of the Monon High Bridge at 2:13 p.m., and that Richard Allen killed them between that time and when a witness allegedly saw a man in blue jeans and a blue jacket on 300 North shortly before 3:57 p.m. In other words, assuming the prosecution's evidence is accurate, LG and AW were murdered after 2:13 p.m. and before 3:57 p.m. on February 13th of 2017. Additionally, assuming this timeline is accurate, the prosecution would have the girls between the Monon High Bridge and the location where the bodies were found from 2:13 p.m. on February 13th of 2017, the bridge video, until they were found at approximately 12:15 p.m. on February 14th of 2017. At the time the bodies of AW and LG were found, LG's phone was under LG's shoe, both of which were under the body of AW. I still find that detail so strange. Beverly said, evening Gisela Mod and fellow Grizzlies, a full 12 months. Happy Grizzlyversary, and thank you so much for being here. If you're only joining now, we're looking at all the latest documents as we've been doing for a while in Delphi. I find it all very interesting. Don't feel overwhelmed. I know some people feel a little bit overwhelmed, with what's going on in Delphi. If you have any questions, like if you want me to make, a shorter video just to summarize what the heck is going on, let me know what your questions are in the comments below, okay? So, here they say, right, that little detail is so odd. Assuming the prosecution's timeline is accurate, LG's phone was under LG's shoe, which was under the body of AW, from sometime after 2:13 p.m. on February 13th of 2017 until the bodies were found at approximately 12:15 p.m. on February 14th of 2017 and had remained at the location in that condition for that entire time. However, Sergeant Blocher stated on February 13th of 2017 that the cell phone was no longer in the area or no longer in working condition. There is no way that LG's cell phone could have been out of the area between 9 p.m. on February 13th of 2017 and 1 a.m. on February 14th of 2017 if the prosecution's timeline is accurate, because the phone was at the location where the bodies were found the entire time. Assuming the prosecution's timeline is accurate, there's no way that the phone was not in working condition between 9 p.m. on February 13th of 2017 and 1 a.m. on February 14th, because we know that the phone was on and communicating with the cell phone tower at 4:33 a.m. on February 14th of 2017. For the prosecution's timeline to work, the phone had to have been in the same condition from sometime prior to 3:57 p.m. on February 13th of 2017, the time the witness sees the man on 300 North, until the time the bodies were found on February 14th of 2017. I can't wait to hear what you guys think about this. So at the time, we're almost there. At the time of the search warrant for Mr. Allen's residence, members of the Indiana State Police were also aware that the last ping, this is all information we didn't know before, so I'm finding this all like, oh wow, especially because we're not going to hear anything from the trial, so I'm getting some information here. Nikki Saturno says, thanks for the coverage, G, hoping for justice for Abigail and Liberty. Thank you so much, and yes. So, they say at the time of the search warrant for Mr. Allen's residence, members of the Indiana State Police were also aware that the last ping of LG's phone was not at 5:44 p.m. on February 13th of 2017, but at 4:35 a.m. on February 14th of 2017. Furthermore, it's evident from the data from LG's phone that the phone was accessed and connected with the cell phone tower at 4:33 a.m. on February 14th of 2017. I find that so interesting. Copper Horse, my word, Copper Horse, a fantastic moderator, a member for 25 months. Oh my goodness. And you said 90 seat capacity in Delphi Court, many to be reserved for family and others. Right? But even 90, that doesn't sound like a lot. I mean, 30 was really sounding low, but like 90? For such a high profile trial? Wow. Rexy said those girls were moved. I've always felt that the timeline doesn't make all that much sense. If it's guys down the hill, they are directed down the hill to go across the creek, and then a murder happened, double murder, and then the person just scurries off. It just like, I don't know, man. I don't know about that timeline. So I'm just finding this phone ping data quite interesting. And Rochelle has been a member for 30 months. Always loved the streams and insights from Gisela. Oh, thank you so much. So they say, now we know the last ping was at 4:33 a.m. on February 14th of 2017. And it's there, like, probably, well, I don't know. Probably near where they were found, right? Because the phone was found there on Ron Logan's property. Never that as well. Lola at Heart says yes, and the undressing and redressing. All of that. So they say, had Tony Liggett submitted an affidavit for the search warrant that did not recklessly disregard the truth, it would have included the following. A. When the bodies were found at approximately 12:17 on February 14th of 2017, There were sticks and branches which appeared to have been deliberately placed on the bodies. FBI Special Agent Nicole Robertson stated that the bodies appeared to have been moved and staged. And so did that former prosecutor Robert Ives. He also said that. He said there were multiple signatures, that the scene had been staged, that the bodies had been moved, and then we found from that Frank's memorandum that Abby was wearing Libby's pants and all kinds of things. Like, it really sounds very hectic. Rexy said, nope, timeline is way off. So, at the time of the murders, A.W. was dating Logan Holder. Logan Holder is the son of Brad Holder. This we know from the Frank's memorandum. And Brad Holder had apparently said that before. So, Jerry Holman of the Indiana State Police consulted with Professor Jeffrey Turco of Purdue University. Purdue University Professor Jeffrey Turco wrote in a report provided to the Unified Command that the markings, referring to the configuration of the branches on the girls' bodies, constitute an inscription inspired by Norse runes or modern recreations thereof is quite plausible. In 2017, Brad Holder belonged to a group practicing and following Nordic pagan beliefs. Brad Holder posted pictures on Facebook mimicking the crime scene. I mean, that was weird. It just was strange. I don't know if you saw that painting. It was actually in my presentation that I made because I never read through the entire Frank's memorandum with you guys because at that time, the court had told me, after sending it to me, that they've now made that private. So I was like, okay, so I want to make a presentation out of it, which is what I did, which was actually great because then we had the visual learning experience, right? We had pictures and bullet points and all of that. So if you missed that, it is on the playlist, okay? Right. Brad Holder posted pictures on Facebook mimicking the crime scene. AW and LG were killed after 2:13 p.m. and before 3:57 p.m. on February 13th. So again, just the sentence up top says, had Tony Liggett submitted an affidavit for the search warrant that did not recklessly disregard the truth, it would have included the following. So this is what they're saying it would have included, right? That, wait, what point was I on? Yeah, there, okay. AW and LG were killed after 2:13 p.m. and before 3:57 p.m. on February 13th, 2017. They would have put that in. I get what the defense is saying. They never put that in. During that time, there were 3 phones in the area where the girls were last seen and the location where the bodies were found. None of these phones belonged to Richard Allen. Now, I know some people have said it would be 2 ladies that were walking on the bridge that day. It could have been them just near, because if they're on the high bridge, it could also be near. The defense is kind of implying that based on geofencing data, which is way more accurate, that there were 3 phones actually pinging at the area at the scene where the bodies were found later. There's also a content creator out there that I'm not naming at all, who just said that they were there that day on the trails and that their phone was taken by law enforcement. So all of that is very interesting. But anyway, okay, 3 phones. On February 13th and 14th, law enforcement requested AT&T pings. LG's phone every 15 minutes. The time of the last ping to LG's phone on February 13th was at 5:54 p.m. and the time of the first ping on February 14th, 2017 was at 4:33 a.m. I kind of like how the defense kind of lays out these bullet points of saying, well, if your probable cause affidavit was credible, it's almost like they're saying if it was accurate, you would have said the following things. And then they're just like giving examples of how it would be worded, right? Ladybug says, I smell a rat. Too much secrecy plus a closed trial? Yeah, I think it's more than a rat, yes. Yes, me too. I smell a rat from way, way back, which some people agree with, some don't. I don't know. Something is just not right. Gut instinct, one just shouldn't ignore it. We all have different concerns in life, and our gut instinct will tell us different things. I'm like, something isn't right in this case, right? I'm really worried for this trial. I don't know what's going to happen. So they said Indiana State Police believed that LG's cell phone was either out of the area of the Well Street Tower or not in working condition between 5:44 p.m. on February 13th and 4:33 a.m. on February 14th of 2017, at which time there was a successful ping to the phone. Could have been turned off, right? Interesting. Especially near Ron Logan's property. Some of the hunting cabins or something. I don't know. I'm speculating for a second. These omissions are so voluminous and significant that there's no explanation for their omission other than a reckless disregard for the truth. Had Tony Liggett not recklessly withheld pertinent information from his probable cause affidavit on the search warrant, the application would have been denied. Wherefore, Richard Allen, by counsel, respectfully requests that the court set this matter for hearing, grant Mr. Allen's motion, and exclude all of the evidence seized as a result of the search of Richard Allen's home, and for all other just and proper relief in the premises. So they're back to asking for the search warrant evidence to be tossed out. They also asked for the confessions out. They also asked for all the data relating to Libby German's phone to be tossed out of the trial. So I find this interesting now that they're like, whoa, wait. On Friday, we got this information and this is what we've learned. So it gets interesting, right? Right after they asked for all of the data on Libby German's phone to be excluded from the trial, basically, is what the defense asked for. Right after that, McClelland, the prosecutor, gave them documents which then highlighted all this ping information, which is interesting as well. Just thinking of that timing, like, okay, they've asked for that to be excluded. So here we go. Look at this evidence. Like, sorry, what? Deb, sorry, I'm trying to keep up with all your messages. Thank you all for all your comments. Deb's in space said, not handing over all discovery and right to a fair trial. Yes. So, what do you think, guys? I think it's so hectic. This one we also looked at, and this was the last one for now. There's snowing documents again. Raining, snowing documents. I don't know. It's a mountain of documents as always. This one is from Nicholas McClelland. Let's see what time he filed it. 2:13 p.m. Okay. He does usually like to file very late. Motion for leave of court to subpoena third-party records. What does he want? Any and all phone calls made by inmate Richard Allen while he was housed at the Westville Correctional Facility and the Wabash Correctional Facility. They're going to be listening to the jail calls, the prison calls, actually, to see, what they can hear there. So, anyway, this document is getting very long now. There's lots in here. We can go over this one another time. But basically, that's what they want. Richard Allen's prison call records. Okay. Yes, aka radar. That's why, yeah. Exactly. That's what we were discussing at the beginning. Diener recused and then resigned effective yesterday, shaking my head. So Steel Guitar says, is anything admissible? Nothing. Basically, the defense has to sit on their hands, not say a word. It'll be jury selection. After that, state will present its case, and then whatever time is left, okay, it's for the defense. Judge Gull is kind of like, I don't know, like how many people are you trying to bring to the stand? They're like a dozen or 2 dozen, to present our case. So the defense is actually worried about how little time they have to present their case to defend Richard Allen. Forrest Nelson, thank you so much. I really appreciate it. Oh my goodness. Thank you very much. Okay, so that's what we have for now. As I say, look, it just goes on and on. We could read every word of this if we really wanted to, but there's so much information. I thought that for now was the most interesting. I hope that you enjoyed learning the information with me. I look forward to hearing what you think about it. Nothing shocks me anymore in this case. Although every time I am shocked, actually, I'm always like, nothing will shock me. And I'm like, what just happened? No. Let me quickly just do a refresh here on X just to see if there's anything that's the latest. So Bob Seagull, not to be confused with Judge Gull. He's a WTHR reporter, said the judge says Richard Allen's public defenders were sloppy, negligent, and incompetent in handling evidence, but she will not impose sanctions because the state failed to prove the conduct was willful and intentional. I just like saying that with some intent. Yeah, the state failed to prove. Shame. It's like salt in the wound for McClelland. He's just like, what? No. Yes. Just a crazy Swifty says, with LG's phone pinging, yet still having video on it is perplexing if that's true. I've seen a lot of theories come out since that as well. Just like, one of the theories was someone said, what if somebody took Libby's phone and then filmed the man on the bridge? I'm just like, wow, there's a lot there. And I'm sure, do you think at the trial they're going to play the full video and audio? I wonder, because of course there's more. All injustices. Gull is sloppy, willful, and intentional. Well, yeah, we'll have to see. That's what I'm saying. This whole case, it's so risky. It's so risky. I mean, it's kind of like, is the judge going to be thrown off the case? At this point, probably not. What's going to happen at the trial? Is everybody going to be safe? Will we ever know what happened in the courtroom without the hearsay? You know what I mean? When I say hearsay, I mean people that are going to be in the courtroom are going to then obviously report on it. That'll be amazing. I can't wait to hear every single word from whatever everybody says about it. I'll be like on highest alert, right? But we have to basically rely on what everybody's going to retell about the day. Yeah, Malibu says, I want that video. Yes, maybe it's a deep fake, the thing that McClelland is very, very scared of himself. He's so scared of deep fakes that I'm kind of like, wow, interesting you brought that up, sir. Anyway, so who knows what's going to happen, but it's 12 days away. 12 days. I don't know. I'm just very nervous for it. I'm sure the families are also. I'm sure everybody's had enough. And yet, there must be a fair trial. So, thank you so much, everyone. It's nice to see you all here and to talk to you all about it. Thank you for hearing me out on it. And as we read these documents, I'll keep you posted on whatever happens next. Make sure you check out the community tab, the YouTube shorts section, because I sometimes update you there as well, okay? Because there's so much coming out all the time. People are sharing the prosecutor's a picture on X. If you're on X, go hashtag Delphi and you're going to see it. You're going to see it. It's very strange stuff, that. Okay, C. Chinny says the final countdown. Yeah, Malibu says this trial's not going to go as we might imagine. I'm scared. So I'll see you all again very soon. Make sure you are subscribed, okay? Put all the notifications on so you don't miss the next, live stream. As you know, I just go live whenever I'm ready to talk about something with you guys. There's no schedule. So I'll see you again very soon. Leave your comments below. I want to hear what you think about all of this. And yeah, see you in the next one. Bye.